Parliamentary Joint Committee on Human Rights was established in 2012. Its main function is to examine all bills and legislative instruments for compatibility with human rights and to report to both Houses of Parliament on its findings.
The changes in the framework are aimed at enhancing understanding of and respect for human rights in Australia and ensuring appropriate recognition of human rights issues in legislative and policy development. The bills will establish the Parliamentary Joint Committee on Human Rights.
The Parliamentary Joint Committee on Human Rights is 10 years old. That's a whole decade of playing a very important role in highlighting the human rights implications of the legislation conceived by the Commonwealth Parliament.
This committee gives a voice to human rights in our legislative process and acts as a method of ensuring the rights of all are protected when bills are introduced to the Parliament. In Australia, we pride ourselves in providing a culture of inclusivity, respect and equality. Through regular conversation with members, ministers and stakeholders, this committee provides a method of enshrining these values in our legislation, whilst promoting and endorsing respect for human rights in Australia.
This committee is such a fundamental part of a human rights framework that can be a part of the check and the balance that we need in our country to ensure that we deliver on our fundamental human rights obligations through the work of the Parliament.
I have to admit that I was rather daunted by the task, because if you look at the 7 international instruments, you could say, well, wait a minute, how do we actually achieve those? But it wasn't necessarily about achieving. What our purpose was to ensure that people understood that they were there, that they were educated about that they considered those things when they were putting together legislation.
The committee is actually an important bridge in bringing international law obligations into Australian law and practice. And so it plays a very important role in encouraging the executive and the legislature to take account of Australia's international legal obligations.
For me, it was a very important role to be able to scrutinise Australia's legislation against the international obligations we have assumed in a broad range of human rights areas. It's particularly important that we demonstrate to the rest of the world in relation to the important human rights obligations that we have accepted, that we in Australia ensure that in our legislation, in our delegated legislation, steps are taken to ensure that we actually meet our obligations.
I think the feature that stands out the most, the feature that is the most important, is the effort that is required and the triumph that is often achieved in ensuring that the Parliament gets to represent a view about our international treaty obligations and whether or not our domestic laws reflect the ambitions of those treaties. It has also demonstrated, I think, the importance of parliamentary views as opposed to partisan views.
I was lucky enough to have a committee that saw that this wasn't about politics, that they could flourish as true parliamentarians in actually doing the work of Parliament. And I think that that's important.
The Human Rights Committee is above politics. Its purpose is to ensure that human rights for all Australians are protected from the legislative impact of government, irrespective of the hue of that government. And the Human Rights Committee ensures that the Parliament is made aware of the impact that legislation will have on the daily lives of Australians.
I think the members of the committee shared a genuine commitment to play our part to reduce the likelihood that the Australian Parliament would pass legislation that was incompatible with human rights.
When I was on the committee, we looked at a range of legislation that impacted refugee rights and also a range of legislation that looked at national security. They were the two areas where the debates were most forceful. And some of those meetings went on for a very long time, and there was not always agreement. But what we did have was that was a dedicated process where these issues were raised. And if it wasn't raised at the Human Rights Committee, where in fact would these issues be raised? Where would ministers, departments and experts have to justify legislation against the various claims about human rights?
The great service that the committee does is to tell Parliament and the public on the record when laws risk violating human rights. But it's those same laws that may well be government policy and have broad public support. At that point, the committee's view is a passive challenge to Australia's willingness to meet its human rights obligations, and whether its view is acted on is a political issue for government and the Parliament.
I think the committee's scrutiny and reporting role remains as important as ever, because at the least it mitigates against the unwitting or ignorant breaches of human rights by the Parliament. And that means it's not possible for those in the Parliament who vote in favour of legislation to say, we didn't know. That then may allow Australian communities in the future, if community standards change or the consequences of that legislation becomes ever more apparent, to then potentially hold decision makers and governments accountable.
Most rights can permissibly be limited. So much of the committee's work is determining whether limits on rights are reasonable, necessary, and proportionate. And often this issue of proportionality is key. So the Committee on Advice is looking at whether limits on rights are subject to checks and balances, to safeguards, to oversight, and overall whether the limit on rights is achieving the aim of the legislation in the least rights restrictive way possible.
This structured approach to proportionality has helped other committees in the system, as well as public servants and other submission makers, to be able to articulate their ideas in a structured, consistent and accessible way. This is part of the hidden impact of the Parliamentary Joint Committee on Human Rights. It is developing a culture of rights scrutiny that has been able to transcend just the legislative design that we see move through the Parliament in Canberra, but also the way that governments think about their role and the community thinks about advocacy in a right space.
One of the other aspects that came very much to my mind was that this form of international law dealing with the treaties that you sign is complex, is difficult. And there is a host of international obligations that are examined in competing treaties where sometimes you've got to rationalise one against another.
Because we found out very quickly that it was not black and white. It was very often competing values, competing rights, and that our job was to really take on board the advice that we received and come up with a recommendation about what was the impact of that legislation, taking into account human rights.
Another important way in which the committee has been able to contribute to greater scrutiny of human rights issues in Australian legislation, and in effect to effect changes, is in its use of the inquiry function. These have provided an important opportunity for the committee to look in a holistic manner at the operation of a particular law or particular laws, and to take into account evidence provided not just by government, but by those whose lives are affected by that legislation.
As well as scrutinising legislation, the Human Rights Committee has an investigative function. It can inquire into any matter relating to human rights once referred by the Attorney-General. To my mind, the Freedom of Speech in Australia inquiry highlighted the crucial role of the Human Rights Committee to be apolitical in upholding human rights in Australia.
And one of the pieces of work that we did was a public inquiry into the legislation that sat before the House on religious discrimination. And I was very pleased with the information that we drew out, the number of submissions that were made, and it's part of hearing our democracy at work to consider the human rights for all.
At the end of the day, when we reflect after 10 years, it's not only the work of the committee that we reflect upon, but we reflect upon that work and the way in which it's influenced the way the whole Australian public service looks upon its obligations of a human rights nature, and also we look upon how that's reflected in an understanding of the Australian public.
I see the first 10 years as a bedding down period when governments have been getting used to being scrutinised and reported on. The committee now, I think, has a solid foundation for its work to be better understood and appreciated, as it continues to do what it can to ensure that Australia meets its human rights obligations in its legislation.
Congratulations on 10 years. I look forward to watching the progress and the evolution of the committee in the next 10 years. Our parliamentary system is a dynamic one. Committee processes and committee customs don't stand still. They are not static. They move with the times. And I look forward to watching very, very closely to see how the Joint Human Rights Committee starts to evolve over time.
For the last 10 years, the Human Rights Committee has served as a really important instrument for our Parliament to examine and uphold Australia's obligations under the many human rights treaties that we've signed and the legislation that we have implemented here in Australia. And I'm really looking forward to, in this Parliament, continuing that tradition of ensuring that Australia remains committed to our human rights obligations, while also examining the legislation that the government is going to bring forward and some other ideas about how we can bolster and strengthen human rights in Australia. It's important work. We've got a great committee and I'm looking forward to it.
To learn more about the committee, visit aph.gov.au/joint_human rights.